How's it going?
What the hell are you doing back here?
All right, it's just
Basically.
No, you don't have to explain nothing to me, man. I'm just messing with you, dude. You know, busting your balls.
Somebody was like, I drove to probation, and someone called probation and told probation I was driving.
Our present case 22 CR 1186, State of Ohio versus Ernest Goodson. Defendant was granted judicial release by this court after having been sentenced to a mandatory prison term. He was put on community control sanctions. Motion to terminate those community control sanctions has been filed. Scheduled for the probable cause hearing this morning. Defendant is here in court with his attorney, Ms. Culotta Regazione. Ms. Regazione, what's the defendant's intentions at this time?
Thank you, Your Honor. I did speak with Mr. Goodson regarding his right to have both a probable cause hearing and a final hearing in this matter. He has indicated he will waive both hearings, admit the violation, and we do wish to be heard as to sentencing.
Thank you. Goodson, you have been charged with violating the conditions of your community control sanctions. Specifically, it's alleged you violated Rule 11, which says you shall comply with all special conditions and orders set forth by the court. And in this particular case, the court suspended your driver's license. It was a mandatory suspension, and I only gave you the minimum suspension of 3 years. And it's alleged that you violated that by driving to the probation department on December 9th of this year. Now, you have the right to have two hearings regarding this allegation. The first is a probable cause hearing, which is a hearing where the state would be required to present some evidence that would suggest you probably committed this violation. The second is a final hearing on the merits, which would be scheduled for a different day and time to give you time to prepare if that's what you wanted. And that's a hearing where the state has to prove the actual merits of what they're alleging. Now, you could have either or both of these hearings, but you can also waive the hearings and plead guilty to the violation, and your attorney has indicated she believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver, your plea of guilty, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If, in fact, that did occur, the court could extend your community control and judicial release up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and return you to prison. At the time the court granted your judicial release, the court specifically reserved the right to reimpose the balance of the prison sentence that was initially imposed, which was 24 months in prison. So I could return you to prison to finish the rest of the 24-month prison term that you served, or that you started serving. Do you understand the potential penalties you face if you are found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to waive the hearings and plead guilty to the violation?
I'm going to waive the hearings and plead guilty.
Very well. As to the allegation, you violated Rule 11 by driving when your license was suspended. What is your plea to that?
Guilty.
The court will accept your plea of guilty, find that you did violate your community control sanctions and judicial release. Ms. Regazione, is there any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. Your Honor, Mr. Goodson is here before you recognizing that he made a huge mistake, but accepting full responsibility for that. When I met with him about this situation, he was very contrite, very clear that he is not making any excuses for his behavior. He recognizes that this court gave him a break and allowed him to have judicial release, and he was really trying to do everything that he needs to do to comply with probation, to make better choices for himself, for his family. Unfortunately, part of that was a decision to drive himself to probation because he did not want to miss his probation appointment, and he recognizes that he should not have done that. He should have made a different choice, reached out to support. He, again, accepts full responsibility, and he did turn himself in when he did speak with probation officer Randazzo, and she told him to turn himself in. He did so. He is working in management for Taco Bell, and I know that Your Honor did receive the letter that his employer wrote, and you did review that letter. He has much support here in the courtroom. He has 2 uncles, he has a brother, his girlfriend, as well as support from AA. He is doing AA meetings. He is, again, working. He has 2 children that he takes care of, and he really recognizes that he made a huge mistake here. He is really asking the court to take all of that into consideration. His brother and his AA support did wish to speak on his behalf. So at the appropriate time, I would ask that they be able to do so. And Mr. Goodson also did wish to address the court as well.
We'll hear from the folks that want to speak on behalf of Mr. Goodson at this time. Whoever would like to speak, you can just stand right where it is that you are seated. Spell your last name, state your name and spell your last name so the record can get that correctly. Then go ahead and say whatever you'd like me to know and speak up loudly enough so that we can hear you.
Yes.
Good morning,
Good morning.
everyone. Thank you for allowing me to speak on behalf of Mr. Ernie Woodson. My name is Diane Harris. To whom it may concern, my name is Miss Diane Harris. I have been a member of Alcoholics Anonymous for 40 years. My anniversary date is January 1st, 1984. I do have an anniversary coming up through the grace of God and His mercy. Thank God for God giving me the courage, strength, and most of all, willingness, honesty, and open-minded to go forward. I'm writing this letter to you for my dear friend Ernie. Since he has been in the program, he has been a good man, a good example, going to meetings, a lot of meetings. We're talking about meetings just about every day. He's been working, he's been promoted, speaking and sponsoring through mentoring others through his example. And he's also, I want you to please reconsider the consequences of his actions and mistakes, that they were not thought out well. They were mistakes. And it's a lot that I've cut out so that I can keep it brief. And I also wanted to say, I was 26 years old when I became sober. I'm 67 now. It works. I was introduced when I was 25. I didn't get it until I was 26. Uninterrupted sobriety. And I can see that this young man has been a powerful example. He has spoken at many, many places. To speak for himself, it's impossible to speak and do what he do if he was not implementing the 12-step program. So we do belong to the same group in AA, and I have adopted him and taken him under my wing as my grandson in AA, and please continue to help him. Thank you. And I just wanted to say that most of the time the penitentiary don't rehabilitate you. They make you worse. So I'm asking you, would you please take this into consideration?
Thank you. I think there was someone else too. Good morning.
Name is Dominic Billups, that's Billups.
Thank you.
I'm the oldest brother of Ernie, and I know that we were here like a little bit ago, but he has changed. He's not out here making a ruckus or anything like that. He's a working man. He's a family man, church-going man. And he goes to AA. If there was a way that he could have gotten here, I believe he would have, without doing the lesser of two evils. He did turn himself in. It was heartbreaking to do, but he did it. So I'm just saying, let him keep doing what he's doing out here, being a good person that he is, being a good influence that he is. Yeah, I'm gonna keep it like that.
Thank you, sir. Is there anyone else? Mr. Goodson, you have the right to address the court before you are sentenced. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor.
Good.
I don't have an excuse. I made a bad decision. I needed to get to probation, and my son was late for school as well. And I took the decision to get behind the wheel. My girlfriend, she was late for work. She normally brings me, but I hold myself fully accountable for it. Like, every time I've been in front of you, it's had to do with alcohol. And this time, literally, I have turned my life fully around. Like, I sponsor people. I do leads at AA meetings. Like, I've gave my all. I gave everything up. Like, literally, I have a full-time job. I'm a general manager for Taco Bell. And my boss and my staff definitely respects me, and they see the work I put in. Like, I am totally a different man. After losing my little sister and my nephew, Your Honor, it made me want to change myself. And I definitely have changed myself. I do apologize. Like, I will use my resources next time. Like, I can call my brothers. I can call my people from AA. Even if it takes a while to get to probation through Lyft, I will make sure I contact them and let them know that I'm sorry, I'm running late. And that's what I should have did. But I made the wrong decision to get behind the wheel. And I hold myself fully accountable for that. I just want to get one more chance. If I get one more chance, I will give you my word. I will not get behind the wheel. I will do everything to my power to make sure I complete probation successfully, just like I'm doing with AA and everything else. I will give my all to it, Your Honor. And like I said, I hold myself accountable. I do apologize for being back in front of you again. It's my decision making that made me here again today.
Anything else you want to say? No. You don't have to. Mr. Gazione, anything else on behalf of the defendant?
Thank you, Your Honor. I would just ask the court to take everything into consideration that has been said here on Mr. Goodson's behalf. I would ask the court to continue him on community control in this matter. He has been in the jail for 12 days on the probation violation, and I would ask the court to consider that as well. Thank you.
And the problem here is twofold, quite frankly. First, you're on judicial release. It's not just regular probation or community control sanctions. You were sentenced to 2 years in prison and I let you out early. When someone violates on judicial release, it's pretty rare they get another chance. Second, it deals with what we had to do. When I say we, I'm talking about Ms. Randazzo, had to do to get to this point. Your lawyer says that you're here accepting responsibility and that you're very contrite. Well, you weren't accepting responsibility and very contrite until she put forth the hours that she had to put forth to show that you were lying to her. She confronted you with this and gave you every opportunity to acknowledge that you were to truly be contrite and to accept responsibility, and you wouldn't do it. You kept lying and lying and lying. And it wasn't until she was able to prove it to you and prove it ultimately to me, that you then became contrite and accepted responsibility. Well, that's not accepting responsibility. Accepting responsibility would have been when she confronted you with it and you said, you know what, you're right. I didn't have a ride. I was scared. I needed to get here. I did it. Not, no. And when she put forth certain facts and to say that, you're with why would you be have your son up here in the jail with all these felons around here if he could be sitting in the car with your girlfriend waiting, and you still maintain that you didn't drive there. And it wasn't until she looked at the videos and was able to show it that you then became contrite and accepted responsibility. Yeah.
May I say one more thing, Your Honor?
Sure.
I think that Mr. Goodson was afraid of violating probation, and although it may have seemed that reaction was lying and making excuses, because of course it was. I think it was driven by the fear that he did mess up.
It wasn't accepting responsibility.
But he did ultimately
Well,
accept
he ultimately did when
responsibility.
when you see videos of him driving the car.
Yes. But again, I guess I would just point out that I think he was scared. That's why he drove to probation in the first place. He didn't want to violate. And then when he did get caught, he was again panicking and realizing that he was going to be violated.
You're driving with your son in the car. If you get stopped, you're going to get arrested. And what's going to happen to your son? He's just going to be sitting there. They're going to have to find someone to come get him, or they're going to call Human Services or Job and Family Services to come get him. You're not going to be allowed to just go because your son's in the car. They're going to do whatever they need to do. And you're putting a big risk there as well.
And I apologize for that, Your Honor. I definitely do. I know that, and for this Christmas, I promised my son that I would be there, and that hurt me the most as well. And yes, I did lie about it. Yes, but I did tell her, you're right. I told her the truth afterwards. And
Well, what are you going to do?
Right.
If she says she has videos,
Yeah.
what are you going to continue lying at that point?
No, not at all. I made the wrong decision. I'm the one to blame for it. I hold myself accountable for making that bad decision. But I guarantee I will not make no more bad decisions.
For sure you made guarantees when you were here for the sentencing, the judicial release last time. I'm a firm believer in actions speak louder than words. I mean, you demonstrate what your intentions are by what you do. I have considered the original pre-sentence report and investigation, the original facts and circumstances from the underlying offense, the nature of that, everything that's been said here today by the family members, acquaintances. I got a letter from an employer. I've read that. Consider what's been said by the defendant, his lawyer, nature of the violation. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, I'll incorporate all the findings I made originally regarding the seriousness factors and the recidivism factors, with the additional finding here today that the defendant has failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. Now, I highlighted the concerns the court has with the nature of this violation, and probation doesn't work if you're not open and honest with the probation department or probation officer. It just doesn't work. Again, like I said, I highlighted the issues that we had here. I will note for the record, the defendant has done well on probation, however, in regards to the other matters. So I'll give you one more chance, Mr. Goodson. But if you're playing games like you were, and probation has to do what they did, and they will do what they did to learn of it, you're gonna leave me no choice. I'll continue on community control sanctions. There's going to be consequences. I'm going to sentence you to 30 days in jail. You have 12 days of credit, so 18 more days. All the other conditions are going to remain the same. You should not use any drugs or alcohol. You must submit random urine screens. They have to be negative. A positive screen is a violation. You're to attend 3 AA or NA meetings and have a sponsor, maintain full-time employment. Did he ever have the mental health evaluation?
He did, Your Honor. There was no need for services.
Okay. 1 doctor, 1 dentist, 1 pharmacy. All the same as before. Take your medications if any as prescribed. No frequenting bars. Pay your court costs and supervision fees. No driving without a valid license. Is there anything else I should be considering?
Nothing further, Your Honor.
Mr. Goodson, you understand all the conditions of your continued judicial release?
Yes, Your Honor.
Any questions for me?
No, Your Honor. Thank you.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime, another motion to terminate will be filed. And if it's found that you violated, I could extend you up to 5 years. I could impose more restrictive sanctions against you, including more jail time. I could terminate your probation and return you to prison. Again, the court specifically reserves the right to reimpose the balance of the original 2-year prison term that was initially imposed. I think that covers everything. Is there anything else for the record, Ms. Regazione?
No, Your Honor.
Thank you.
All right.
here today in state of Ohio versus Brian A. Yarbrough. Case number 24CR001346. Defendant is present at open court today with his counsel, William Watson. Your Honor, we're here today for an in-court arraignment. On December 20th of 2024, defendant was indicted on a 7-count indictment, including felonious assault, felony of the 2nd degree, 2 separate and distinct charges of assault, felony of the 4th degree, vandalism, felony of the 5th degree, resisting arrest, misdemeanor of the 1st degree, failure to comply with an order or signal of a police officer, misdemeanor of the 1st degree, and violating a protection order, misdemeanor of the 1st degree. It is the state's understanding he has been served with the indictment and has requested it in court. The state is asking that bond be continued with what the municipal court set it at 15,000 cash surety or 10%. I can give further information if and when the court wishes.
In regards to count 7, the protection order, who does that involve?
The name is, I believe, Kimberly Ellis.
Thank you. Watson?
Thank you, Your Honor. May it please the court. My client is in receipt of the indictment. We will waive 24-hour service, waive any service defects, waive reading of the indictment. I'd like to enter a plea of not guilty to all the charges, and we would respectfully request that the original bond be continued. And, Your Honor, if I may have just a brief moment right before the court, my client wanted to speak to me. Would that be okay, Your Honor?
Sure, go ahead.
Thank you, Your Honor. Nothing further, Your Honor.
So you're agreeing with the bond?
Yes, Your Honor. My client, I did not meet with him initially, but it was my understanding, Your Honor, my client did not want to sign the paperwork. He wished to have an in-court arraignment. That being said, we're not raising any issues on bond, Your Honor.
Yarbrough, you received the indictment?
Yes,
You have a chance to look it over?
yes.
You do have the right to have me read that indictment to you, and I'll do that if you want me to. But you can also waive the reading of the indictment. It's up to you. What would you like to do at this time?
I think I'm understanding of the charges.
So you waive the reading of it?
Um,
You want me to read it to you?
yes,
You want me to read you the whole
Yes.
indictment? Okay. One, it's alleged that you, on or about November 4th, 2024, in Eastlake, Lake County, Ohio, did knowingly cause serious physical harm to Patrolman Maximus Hines. That constitutes the offense of felonious assault of felony of the 2nd degree. In count 2, it's alleged on or about November 4th, 2024, in Eastlake, Lake County, Ohio, that Brian Yarbrough did knowingly cause or attempt to cause physical harm to Patrolman Maximus Hines. The victim was a peace officer while in the performance of his duties. That is a felony of the 4th, that's assault of felony of the 4th degree. Why is count 1 and F2?
Your Honor, this is not my case. I did not indict the matter. Ms. Horonic did.
Who?
Sarah
Moronic?
Horonic, thank you.
When I say why isn't it a felony of 2nd degree, it should be a felony of the 1st degree, but it's not indicted that way. Not that it's more serious, it should be more serious. In count 3, it's alleged on or about November 4th, 2024 in East Lake County, Ohio, that Brian Yarbrough did knowingly cause or attempt to cause physical harm to patrolman Jacob Reich. The victim was a peace officer in the performance of his official duties, which makes the offense assault, a felony of the 4th degree. In count 4, it's alleged on or about November 4th, 2024 in East Lake County, Ohio, that Brian Yarbrough did knowingly cause serious physical harm to property that is owned, leased, or controlled by a governmental entity, that being the East Lake Police Department. That conduct constitutes the offense of vandalism. It's a felony of the 5th degree. In count 5, it's alleged on or about November 4th, 2024 in East Lake County, Ohio, that Brian Yarbrough did recklessly or by force resist or interfere with the lawful arrest of himself, and during the course of that resistance, or as a result of that resistance or interference, caused physical harm to patrolman Maximus Himes and or patrolman Jacob Reich, who were law enforcement officers, which makes the offense resisting arrest misdemeanor of the 1st degree. In count 6, it's alleged on or about November 4th, 2024 in East Lake County, Ohio, that Brian Yarbrough did fail to comply with a lawful order or direction of a police officer invested with authority to direct, control, or regulate traffic. That conduct constitutes the offense of failure to comply with an order or signal of a police officer. It's a misdemeanor of the 1st degree. Lastly, in count 7, it's alleged on or about November 3rd, 2024 in East Lake County, Ohio, that Brian Yarbrough did recklessly violate a term of a protection order or consent agreement approved pursuant to section 291926 or 3113.31 of the revised code. That involves you said Kimberly Ellis? Is that different
That is
from,
correct.
is that someone different from Kayla Ellis?
Yes, Your Honor.
That conduct constitutes the offense of violating a protection order. It's a misdemeanor of the 1st degree. Do you understand the charges that you're accused of committing?
Yes.
And at this time, what is your plea to each of those 7 charges?
Not guilty.
Coral enter plea of not guilty to each of those 7 charges. Will be continued at $15,000 cash surety or 10% in order that the defendant have no contact with any of the victims or the subject of the protection order. Is there any other conditions? I don't see anything else.
No, Your Honor, I can verify, but I just have a notation of 15,000 cash surety, 10%. I didn't see any no contact.
No, there isn't, but I'm ordering that
Okay.
as a condition. But yeah, you're right. That wasn't original. All right, anything else for the record, Mr. Watson?
Nothing further, Your Honor.
Ms. Cutts?
No, Your Honor, I do think they would ask you to write it as reset instead of continue just because of the addition.
I do that.
Thank you.
All right.